Hello everyone. How we doing? It is Friday. I have stuff to do. Not really. I am here to hang out with all of you. We are here to have some fun. I am your friendly neighborhood Prax. Welcome to the channel. Thank you everyone for being here today. I am going to try and talk about the new draft version of the OGL. That is the Open Gaming License. I am your friendly neighborhood Prax. I play tabletop games. I write tabletop games. I even, on occasion, run a lot of tabletop games here. We play some video games, we do some fun stuff. But today we are going to continue our discussion of the OGL and everything that's been going around with that. Wizards of the Coast, when I talk about... Okay, so I should step back and do a couple points. Point number one. Hi. I am your friendly neighborhood Prax, here to help and support you all, but I am not yet a lawyer. I will currently a law student, a 3L law student, and a legal intern. What that means is I can sign legal documents and argue things in court. I am, however, not yet admitted to a bar in a particular state. And I operate under the supervision of an attorney when I do those things. I am not, this stream will not constitute legal advice in any way, shape, or form. Hashtag not legal advice. This is a conversation, an analysis, and this is my personal breakdown of the new document that was released by Wizards of the Coast yesterday. They're officially their draft license, but unofficially or what they're calling it is their playtest license, which, look, I'll be honest, I'm all for, staying on brand and keeping to branded language and using all of that, but not when you're talking about legal stuff, right? Like, when you're talking about legal stuff, stick to things that people actually understand and that won't get covered. And my hair looks great today, but it's a thing. So there is a lot in this document that we're going to talk about. Nothing I say is legal advice, for multitude of reasons. And I would like to remind everyone, it is hashtag it depends. Right? That is the most important phrase that a lawyer will say, and a lawyer should frequently say, because everything in the law is case facts dependent, right? Yeah, Hawkeye, it depends. Hashtag it depends. I'm currently working on something for that. It'll be great if it works. We'll see what happens. But you can, and as I've said before, you can ask 5 different lawyers the same question and come back with 8 answers. Because the facts of each individual case are going to change the way the law interprets that case. The law in the United States and in other ties to countries with British common law all are based on a history of common law, a history of stated statute, long, complicated interpretations of law. That's all dependent on the individual facts of that individual case, right? So what we're going to talk about is what I think of this document, and what my analysis of this document is, and is not in any way, shape, or form the end-all, be-all, only right answer that exists on the internet. And if any lawyer turns around and tells you that there is only one right answer for a legal question on the internet, short of the Supreme Court has the ultimate authority, then don't trust them. Realistically speaking. That's it. It's the only question where there is one answer. And that is the Supreme Court trumps everybody. So today we're going to be looking at this new document. I've read through it once. I have some analysis points, I think, that are important. I think I also have some points where I think we need to focus in and change the conversation. I've been seeing a lot of comments online, a lot of, what's the word I'm looking for? Oh yeah, incendiary language and commentary, and hyperbole. Although I don't know that those people know that what they're saying is hyperbole. And so we're going to try and break it down and explain it as simply as I can and focus in on a couple points that I think are the most important and would be the most beneficial for people who are involved in writing for tabletop games, writing for Dungeons and Dragons in particular, people who play these games, people who do other things, fan content, all of that. And again, if anything I say is you feel might be important, I urge you to consult with your own attorneys. Because this is not legal advice. This is just a breakdown. And sometimes that can help you find the right question to go talk to your attorney about. But at the end of the day, I am not your attorney. I don't have your own personal facts in front of me. I cannot give you legal advice. And so if you have particular questions, you need to take those particular questions to your own attorney and get answers. And that's the truth for, Paizo all the way down to, I wrote two adventures and I published them on the DMs Guild, right? That's just because there is a mass level of difference in those two extremes doesn't mean that the general answer of consult your own attorney is sometimes very important. But we should dive in, should we not? Let us dive in. Let us see what the words on the page will take us to. So, first off, this is an announcement that was posted on D&D Beyond. Now, it's been very interesting that so much of this... Hello, Faison, welcome. So much of the communication about the new version of the OGL has been coming off of D&D Beyond and not the Wizards of the Coast D&D website. There's been a lot of speculation about why that is. There's been a lot of speculation about what's going on. It's also very interesting because all of the other quote-unquote playtest materials, the Unearthed Arcana, all of that information went through the D&D website. The existing license is available on the D&D website. I'm not sure why Wizards is choosing to use D&D Beyond as the mouthpiece for this. I could think of a number of reasons, but I'm not going to say anything in particular. I'd also like to point out that no, I do not pay for a subscription to D&D Beyond. I never have. So, yes, I am on my D&D Beyond, but I don't actually pay for one. I never have. So, this is their announcement, and it gives a breakdown of what they think or what they want you to believe the document says. This is a very good breakdown from a non-lawyer trying to explain legalese to other non-lawyers. Probably got some help with that. However, we're going to look at the actual license itself, and rather than somebody else's interpretation of what it says. And that is always my recommendation when you're considering involving something with licensing or contracts, and that includes a TOS or any kind of contract like that. Go and read the original contract. Don't fall into the trap of, well, someone else told me this is what the contract said. No, don't do that. Read the contract for yourself. Or if you are not a lawyer or have attended law school, get your lawyer to read the contract. That is what they are there for. They are there to help you. But know actually what the individual terms are, and that includes TOS, this license, your policy for your insurance company. Read through that, because that's technically a contract as well. But we're looking at this document, and now, right off the bat, the first thing we're going to tell you versus the leaked document that we talked about last time, this is watermarked a draft. Draft for discussion purposes only. This is obviously been put together by an attorney. This document has all the designations on it that I would expect from an attorney to be making for a document to be reviewed by a client or an in-house review, even, or shared with the opposing side or the other side of a negotiation or the other side of a contract. It's always labeled as a draft, and then there'll be a number of things back and forth, and then there's usually in the hello Dr. Trefanis, welcome in. So usually, again, this is marked as a draft, and there'll be a lot of back and forth, and all of them will be marked as drafts. And then in the final version, which is the one that everyone will agree, which in contracts or even in licensing will be the one that people agree to. How much you actually have authority or power in a negotiation like this is non-existent, but it doesn't really matter, because your use of the license means you're agreeing to it the same way as if you click a TOS button, you're agreeing to that license, or you're agreeing to that contract. But in the final version of it, it will include a clause that is your basically summation, basically a clause that says that any of the previous versions of this document are subservient and sublimated by this final version. Everything else after the final version is, doesn't matter, and it doesn't matter what was said in those drafts. Only the final version matters, which is pretty standard contract. I mean, that's almost every contract will do that. Every contract license will do that. Everything will do that, because it basically means that, any negotiation that you've had before, any back and forth about changing this particular term or changing that particular term, means that you'll come to a final version, and it is the final version which is the only one that matters. And you can't come back 3 months later and say, well, I've got draft number 2, and I think we should be operating under these particular terms that are in draft number 2, but are not in the final version. And the court will turn around and say, no, this is your final version. You guys agreed to this. There were 3 other drafts between final version and draft 2. Obviously, there was a discussion where they didn't want those terms anymore, so it doesn't matter. We're sticking with draft 2. We're going to stick within the 4 corners of the document. And that is what we call intrinsic evidence. Extrinsic evidence is something, would be, well, we thought we were saying this. We really meant to say X. That's what we call extrinsic evidence or parole evidence, and is very, very, very rarely admitted. And it will never be admitted if it is contrary to the terms that are in the document that is finally signed. Because the court's kind of the opinion of if you really didn't want to agree to this, then why did you agree to it? So first of all, we know it's a draft. We see that it's broken up into 3 sections. We have the introduction, the draft OGL 1.2, and we have the draft Wizards of the Coast VTT policy, which is going to be interesting because there's been a lot of talk about that. We'll come back to that one. You can also see that it's 6 pages. Well, we know the current license itself. Oh yeah, I need to make a lurk command. Go ahead, enjoy your lurk. Thank you, we appreciate you. Hope you can get all the things you need to do. But, so we know that this is 6 pages. We know that the current license of the OGL version 1.0A that's available on Wizards of the Coast's website still is like 328 pages, but the license itself is only 2, and the remaining 326 pages is all SRD, right? The systems reference document. So this is, at first glance, a much more cohesive, looks like it'll probably be 3 pages for the license itself. Okay, so that makes sense depending on how much information is on the page and how it's laid out. It might not be laid out in final version yet, so we'll see what happens. Well, actually, I do know, but we're going to talk about it like this. So the first thing is Introduction to the Systems Reference Documents 5.1. Now, this is interesting. The SRD is going in front of the license. I'm assuming that's not going to stay the same going forward. Because the SRD, you know, I don't know, I guess it could, but it's the SRD is the information that is being licensed, and therefore you would usually put the license in front of what is being licensed so that you know and make the agreement. But it is also just an introduction and a breakdown of explaining how this document is supposed to work, theoretically. So there are ways, you know, ways to create. Dungeons & Dragons content is available to you in many ways. Core D&D mechanics, which are located at pages 56 to 104 and 254 to 260 and 358 to 359 of this systems reference document. Okay, so right now they're giving you the page numbers, right? And they're giving you specific page numbers that are licensed under the Creative Commons. But it's specific page numbers of the SRD. So if we assume that the SRD begins at page 1, right? If we assume the SRD begins at page 1, that's pages 1 to 55, 105 to 253, 261 to 357 that are not going to be added to the Creative Commons. This is a much smaller amount, right? And they're also saying that these information on those pages is going to be added to the Creative Commons Attribution 4.0 International CC BY 4.0. So based on what we've seen, and since the draft of the, I wanted to check. I didn't see a link. Yeah, I just saw the link to the, here. There's only the link to the, this page, this document, not any link to any updated SRD. I guess the question is, is it the current, okay, no, I'm not clicking that. Media, articles, events, story, gameplay. Products. Why don't you just have a search button bar on this stupid thing? Maybe it's under basic roles. Resources. Okay, I was trying to find the actual SRD itself. Okay. Okay, okay, so we do have, okay, so this is the original SRD. So they are citing 5.1. The SRD is the same one that currently exists, right? So this document, the existing document, is 403 pages. The first 2 of which are the license that we know are being replaced. And now, according to this new document, new license, The core mechanics, which are located at pages 56 to 104, 254 to 260, and 358 to 359. Stop and think about that, right? That is a grand total of, hold on please, I must math. I will attempt to math. So 254 to 260, that's 6 pages. 258 to 259, that's 1 page, 7. 56 to, that's 48 pages, so 48, 49. Words in my head. 55. There are 55 total pages that are being added up to the Creative Commons of a total document that we know is 400 pages long. Stop and think about that. Everyone's saying, oh, they're adding the core rules to the Creative Commons. Yeah, but only about 55 pages of the 400. Right here, right? So what are they actually adding according to this document? 56 to 104. Let's jump to 50. Oh, come on. Why does it never want to do what I want? Oh, because I'm on the wrong thing. Duh. It'd be really hard. I'm a professional. Alright, so 56. So everything beyond first... Okay, so starting with beyond first level. Yeah, so actually... Yeah, so beyond first level. So none of the race species or race breakdown, none of the class break explanations. All of that is still going to be not part of the Creative Commons. So 56 is through 64. Okay, so this is languages, inspiration, backgrounds, equipment, armor, weapons. Okay, so it ends in the middle of weapons. I'm assuming... Oh, 56 to 104. Wow, I'm doing things backwards. So, weapons... Not 64. 104. Duh. Having a moment. All of the equipment, tools, mounts, trade goods, food and drink... Ability scores, proficiency, how to roll the dice. The breakdown of what each check means. Saving throws, time, movement, terrain, environment. Combat rules. Actions in combat. Healing, vulnerabilities, the different types of damage. Knocking out a creature, temporary hit points, mounted combat, underwater combat, spellcasting. And magical effects. So, the generic basic rule set for how to run a game, which are the mechanics, they're releasing under Creative Commons, which means I could, if I wanted to, copy and paste this entire section right here and put it in there. Hi, Jer, welcome in. So, yes and no, right? Like, technically this is all mechanics, But what they're adding to the Creative Commons is the expression of those mechanics. Because the action of rolling a d20, adding a modifier, and then using that as a way to say that you've cast a spell, that is mechanics. But the specific statement of each spell description begins with a block of information, including the spell's name, level, school of magic, casting time, range, components, and duration. The rest of the spell entry describes the spell's effect. Those two sentences would still technically be... Oh, no, I know you're being snarky. I'm being pedantic. Would still technically be under copyright because it's the expression of those mechanics. And it is a great benefit to have these be reproducible, I guess. And then it jumps to 254, which is the types of monsters: alignment, armor class, hit points, special traits, reactions, limited uses, and legendary creatures, including legendary actions. And then leaving out, so far it's what's being added to the Creative Commons is the basic rules, the explanations for all of those rules, the explanations for monsters for DMs. None of the species breakdown, class breakdowns, spell names, spell descriptions, monsters names, breakdown, descriptions, stat blocks. And then the last piece is 358. Oh, and these are status effects, right? Then the explanations for the status effects. So here's where I'm going to get really pedantic, because I did have this discussion with somebody online. And I didn't mention this in my last stream because it is a concept that exists, but it is very hard to prove, and sometimes is a very, very difficult concept. So there exists something in copyright law particularly called merger. And merger is when the expression of the idea is so tied to the idea itself, the mechanics of the idea, that the two merge together and the expression of the idea no longer has copyright protection. Things like arranging an index by alphabetical order, right? Like, you can't copyright that. In this case, the argument some people were making online for the previous draft OGL 1.1 that people got very upset with, rightfully so, in my opinion, people were arguing that there is no copyright protection for any of the SRD because it's all merger. I don't think that's true. Because to prove merger, you have to prove that there is no other way you can express that idea or concept, and it's not only that it's the only way, but it's really the only way that people can think of. And given the existence of so many other types of tabletop RPGs, arguing the point of expression of merger would be very difficult. However, reading through what portions of the SRD they're adding to the Creative Commons, I would believe, it is my belief, again, not yet a lawyer, and this is not legal advice, but it is my reading and understanding of what they've specifically chosen to add to this, is those are the portions that would be easiest for someone to argue had achieved merger, right? Because if we look at, when your character gains a level, he or his or her class often grants additional features as detailed in the class description. Okay, all of this you could possibly argue is the only effective way of expressing the idea of how your character levels in the game Dungeons and Dragons or a similar D20 based system that uses the same mechanics. So what I'm seeing here is that they've just preempted any argument for merger by putting it under a Creative Commons license. And by putting it under the license, you can't argue that what's under the license is not... By using the license, you then will not be able to argue that the material that's under the license is not in fact protected by copyright. And Creative Commons means it's pure attribution. They're not going to make any money off of the particular portion, but they can still require that you're still required to say that this was created by Wizards of the Coast. It belongs to Wizards of the Coast. So there's a lot of interesting points on that. What? Oh, duh. Okay, come back. So make this a little bigger for people to read at home. So the core mechanics, which are located on those pages of the system reference document, but not the examples used on those pages, that's a very important... This is important. Not the example used on those pages. So if we went to... So Jer asks, once something goes Creative Commons, can a company pull out of the Creative Commons with a license update? Just curious. And this is where I go back to, it depends, right? Because a license, the court looks at it and say, you own the thing. What you choose to do with your thing, as long as it doesn't violate any rules, is your right. You know, you own the thing. It doesn't violate any laws, and it's not actively harming anyone. You can choose to do what you want with your thing. However, what people can argue is reliance, that they believed and relied on your statements that this thing was going to remain X, and therefore they planned their work, their product release, their Kickstarter, all based on this particular thing, and they are relying on you to keep your word. Now, a reliance argument is not one that provides financial compensation. It's one that provides usually equitable compensation, and usually requires the person who is who breaks the contract to have what we call special performance. The court will usually mandate in those cases that the either you pay the expected amount that the individual would have made on the if they were able to complete the contract as was done, or you are forced to perform on the contract. Going in or out of Creative Commons gets a little fuzzy because of the way the Creative Commons license itself is written. I do not, at this moment, believe that it would be possible to change what has gone into a Creative Commons license without changing the property, right? So, for example, if Wizards of the Coast chose to put the SRD for 5.1, or those portions of the SRD for 5.1 into the Creative Commons, until they change the language of the SRD and basically say, this SRD is no longer valid because we've changed the language, we're not making that game anymore, we're not doing that anymore, they can't take it out, right? Like, so it wouldn't be a license update so much as a product update that would be able to do it. And even then, I do not believe that it could fully be removed, although you can destroy your own property. and you would have to someone would basically have to take control of the property to remove it from the Creative Commons. I think it would be very difficult to do. And I think it would be too much of a legal hassle for even somebody like Hasbro to do well. So this new update, okay, again, so very, very limited, extremely limited into what is going into the Creative Commons. Our copyright rights, you could just say our copyrights, in the other content included in this SR systems reference document are licensed to you under the new license, which we're going to look at in a second. Use of D&D content in virtual tabletops is allowed on the terms of Wizards virtual tabletop policy. We'll definitely take a look at that. The use of D&D content in streaming, fan art, cosplay, and other fan content is permitted as described in the fan content policy, which again hasn't changed, right? Like the fan content policy hasn't changed, and I'm pretty sure there are reasons why. Platforms such as D&D Beyond and DM's Guild provide additional paths to sharing your D&D content. Yeah, because DM's Guild, Wizards takes 50% off the top. Hi. Okay, and then putting a creator badge on your... requiring them to put a creator badge as a licensed work. That's not uncommon. We see that actually in current licenses for other games. One that we looked at in the first of this series, which I will make a point of putting in a link in the a card or somewhere, or a link below when this goes up on YouTube to the previous of these. But one of the things we looked at is that there are there are indie games that basically are operating under SRDs that I honestly don't, that are much more obvious, that don't need them because of mechanics cannot be copyrighted, but still requiring people to put attributions or a content, are you part of this particular content? Are you using this particular license to mark on your product that it is a licensed product? That's not uncommon. Almost everything that's licensed, you see that, right? Like if you go into a Toys R Us, right? Or you don't have Toys R Us anymore. Rewind. If you go into Target and walk up to the toy section and you see a stuffed animal that's shaped like Mickey Mouse, there's a tag on it that says either made by the Disney Corporation or licensed to X by the Disney Corporation, to prove that it is official licensed content and licensed product. Requiring people to put that license mark on the item and the new thing that you're putting out for the OGL, I don't see a problem with that. That it's their own, they own the intellectual property, they can require that. And actually I think that makes sense, so that the customer, and this is where we get into the difference between copyright and trademark again, right? Like copyright is the physical manifestation of the expression of the idea put out into the world that you can interact with. And you own copyrights in that the minute the thing is created. But the trademark, right? The trademark ampersand that's a dragon blowing fire, the interlocking D&Ds, those are all trademark Wizards of the Coast, trademark Hasbro. They do not need, those do not have a term limit. They can renew those trademarks as much as they want. They have invested in them. They're tied to the concept of goodwill, tied to the brand. And goodwill here doesn't necessarily mean you have to always have positive emotions about it, but you know that the thing that has that trademark on it is actually tied to the brand that has that trademark, right? So once you've got that trademark, and you've got that trademark going, requiring people who are going to be using the SRD or talking about Dungeons and Dragons or saying that they're creating something under the OGL and requiring them to put a mark on it to say that yes, it is actually complying with the thing, it is actually part of the licensing, means that it's easier to protect the trademarks, which is a big thing, and to fight against trademark infringement. Trademarks are a massive thing at the moment. So right now, we know that this document is currently 50 times better than the previous document, but we haven't looked at the actual terms of the license yet. That's what I want to do now. So, license. Draft for discussion purposes only. This is not the final version. This will not be released for publication. And actually, I think they're just stretching the discussion purposes only by releasing it online, but that's what they've established a pattern of using for the UI for Unearthed Arcana, so I think that's going to cover them. Okay, and you can tell right away that this has not been organized the way the current OGL 1.2 is. And again, immediately, the first thing you read, this is a license between Wizards of the Coast, Wizards, us, we, our, and anyone who wants to use the licensed content in their own TTRPG, you or your. This sentence delineates who are parties to the contract, who are parties to this license. If you don't have this, and it isn't specific, then it's not a binding contract. You can't have a binding contract without the both parties being identified. It's one of the Contract 101. Real important parts. Which is why all of those other indie publishers who were using the OGL to publish or license their own mechanics systems and SRDs had a problem because they never changed the names on the license. Don't do that. I'm glad so many people are fixing it. The next statement. By using our licensed content, you agree to the terms of this license. As used in this license, we, or any other term referring to us, includes our affiliates, successors, and predecessors. Again, very standard language, and immediately, much more than the previous draft document that we saw, much more sound. And that's why I go back to that original, and I said this in the second stream we did, where we looked at the leaked document, and I'm very much of the opinion that the leaked document wasn't the license itself, although it included portions of it and quoted portions of it, but rather the draft write-up for this, you know, explaining what they want the license to be and how they want people to use it. A layperson's explanation of the legalese, or a marketing person's explanation of the legalese, rather than the actual terms of the license. This is obviously the actual terms of the license, and is therefore already a step much further in the direction, and I think to most people a benefit. So it's going to cover licensed content. It gives you a breakdown and an explanation of what that is. License covers only the material and the SRD, and any subsequent version of the SRD we release under this license. They're reserving the right to update the SRD when they want. That was not licensed under the Creative Commons, so basically the mechanics rules that they already put in there. You may use that content in your own works on the terms of this license. Our unlicensed content. Only our licensed content is licensed under this license. Any other content we release or have released is not licensed under this license. Basically, it goes back to what we know from the original OGL 1.0. It's the explanation of product identity, and you can't use anything from the far Forgotten Realms. You can't go to Dragonlance. You can't go to Spelljammer. None of that. Theros, Ravnica, none of that. Your content. This is your creative contributions to your works that are not our licensed content. Basically, anything you wrote that you did not copy and paste directly from the SRD. Your world descriptions, maybe a spell or homebrew subclass, or your subclass, descriptions of spell effects, any of those things. Works covered. This license only applies to printed and static electronic files. Here you go. This is exactly what it was under the OGL, just not as explicitly stated. You create for the use in or as tabletop role-playing games and supplements, and in virtual tabletops in accordance with our virtual tabletop policy. Okay, so now they've added this clause. Yeah, no NFTs, but this, again, this license also was never designed for anything. NFTs, art, streams, VODs, videos, performance art in the middle of Times Square. I don't care. None of that was designed under the OGL. It was only ever for printed materials, and only ever for printed materials that were not going up on the DM's Guild. This is the other important thing. If you put something on the DM's Guild, immediately it is no longer under the OGL, it is now under the licensing agreement for the DM's Guild. That's an entirely separate ball of wax. And now they're creating a new tabletop policy, which we are going to have to look at. I'll go ahead and open in a new tab, so we'll come back to that in a minute. Your licensed works. This is the part that gets interesting. To be a licensed work under this license, it must be a work covered as defined by Section 1B. So there you go. Anything on that. Contain both our licensed content and your content. And not contain our unlicensed content. That is very straightforward. If you want your work to be considered a licensed work and not be considered an infringement of their IP, which is why this is put here, right? This is put here so that you know what you cannot do and where you are on the good side. So if your work that you create, that you publish and then put out into the universe, not on the DM's Guild, anywhere else, but not on the DM's Guild, is work that fits the requirements of Section 1B, contains stuff from the SRD and stuff that you created, and it doesn't contain anything that is not part of the SRD. Sorry, you can't have Driss show up in your game. He just can't. You can't have Vecna show up in your game. He's licensed well, he might be okay if you play him as he comes from Greyhawk, but not as he plays for the Forgotten Realms. Actually, the current existence of Vecna means that you can't use him. Sorry. This is their explicit statement here. We are only licensing you our copyrights in our licensed content, which basically means we are only giving you this particular content and nothing else. You don't get to play in our sandbox free and clear. You get to only do what we want, and we are retaining our copyrights and enforcement for everything else. And you can only do so... We are only licensing you our copyrights in our licensed content, except that under Section 5A, we also grant you a trademark license to... Okay, yeah. That's basically what that says is, oh yeah, we're also licensing you the right to put this this trademarked emblem on all of your content so you know it is approved and the consumer knows that it is also approved. It fits within our guidelines. as further detailed in the Creator Badge Style Guide. Ooh, look, another new document. Lots of new documents. And this is where I go back to my previous statement. If you are a writer, a creator, a person who wants to put effort and money into this space, talk to your attorney. Talk to a lawyer. Find one. Preferably an IP lawyer, but most general counsel can give you at least a rough idea and concept. You know, don't immediately go to like specifically a divorce attorney. That might not help you, but like a general lawyer, general practice lawyer, they can help you. And if you're thinking about doing this professionally for a period of time, and more than just, I've put one thing out there and it exists and I don't really care, then you should be talking to an attorney. If this is going to be a business for you, you should be talking to an attorney. The minute you make an LLC, you should be talking to an attorney. And this is where you get to actually determine what specifically you get. In consideration for your compliance with this license, you may copy, use, modify, and distribute our licensed content around the world as part of your licensed works. This license is perpetual, meaning that it has no set end date, non-exclusive, meaning that we may offer it to others a license to our licensed content or our unlicensed content under any conditions we choose, and irrevocable, meaning, there you go. This is the biggest change from this license and the original license that they've got here, because this license does not contain the term irrevocable. Your perpetual, worldwide, royalty-free, non-exclusive license with the exact terms of this license are open game content. Here's the interesting thing. This one specifically states perpetual, worldwide, royalty-free. This one says perpetual, non-exclusive. Oh, no, around the world as part of your licensed work. Okay, so worldwide, perpetual, non-exclusive, and irrevocable. It also cannot be modified except for the attribution provisions of Section 5 and Section 9A regarding notices. We're going to come back to this, because you know what it doesn't say? It might say it somewhere else and I missed it, but you know what this doesn't say? It doesn't say royalty-free. The license itself, and that's the important thing, is everything else around this is definitions, right? We count this as definitions. In contract law, we consider all of Section 1 definitions. We consider clarifications, content you own, warranties and disclaimers, modification and termination, miscellaneous notices, waiver of rights, severability. Oh, they've included a severability clause. Well, that's in the original too. And that's it. So the actual license, the thing that gives you permission, is this section here. This section here, which is going to be considered by the court the most important section, because that is the actual thing that you are agreeing to. In court, the belief of a contract requires what we call bargain or consideration. And for consideration, you have to a promisor and a promisee, right? Like, one person promises X in exchange for Y. Yeah, I'm not seeing royalty-free in this document anywhere. They haven't put a royalty price on here. They haven't put a royalty point in here, but they haven't said it's royalty-free. They gave you your they gave you your perpetual, and then they gave you the irrevocable within termination guidelines. There is a terminations clause in here, which is not the same as irrevocable. If you're terminating a license, it's because of the contract's been broken, rather than revoking a license, where you look at a contract and say, or you look at the license and say, I want to change something about this, and because it's my thing, I can take it back and I can change it as I want. I don't see royalty free here. So far we've seen 2 points on this document that are easy to gloss over and think of as good things, but when you stop and think about them, are maybe not so good. Now, I'm also going to say, I bet you, and if you try, but here's the other thing is like, and people are like, well, I need the OGL so I can be royalty free. I'm like, well, you publish on the DMs Guild, right? It's like, yeah, you're paying royalties already because Wizards of the Coast takes 50% off the top. That's under the rules of the DMs Guild. So yeah, there's nothing in this draft about being royalty free. And so far, what it looks like, the only terms they've added, the only content that they've added to the Creative Commons license is content that could be argued is expressions of mechanics that would fall under the concept of merger. I don't know how well or how successfully that argument would go. It would probably really depend on the judge. Again, it depends. Is a thing. And so there's a lot of gray area there. But what they've they have not added 90% of the 98% of the OGL of the SRD, excuse me, of the SRD to the Creative Commons. Okay, so Unstable Dios, mechanics are not subject to copyright protection. Expression of that mechanic is. So when I say the mechanic of rolling a d20 and adding a modifier to determine whether or not you succeeded on this jump check, that is a mechanic that can't be subject to copyright protection. However, if I look at the SRD, right, and the current SRD that exists is this document here, and I look at this this breakdown of gnomes. Alignment. Gnomes are most often good. Those who tend toward law are sages, and blah, blah, blah. All of this would be subject to copyright protection because it is indeed an expression. It's where we get here, this beyond first level point, where you could make an argument for merger where the expression of the idea has become so tied with the idea itself that there is really no other way to express it or say it, and therefore would lose any possible copyright protection. And that gets a gray area. Merger is a great concept in law, but it's one of those very difficult to argue points. And is usually not... There's a high burden of proof tied to arguing merger, right? Like you as a person. So what would happen is... Exactly, Ger. The words aren't copyright, but the sentence is. So for example, everything in this part that they're adding to the Creative Commons, the sentence, as your character goes on adventures and overcomes challenges, he or she gains experience, represented by experience points. That sentence, I would really, like, the concept of experience points based on you achieving experience points based on going on adventures, that is a mechanic, and that concept itself is not copyrightable. But that particular sentence, I can think of 4 different ways to write that sentence. So I would not think that merger really applies. However, this is the point where it would be, what is being added to the Creative Commons is the points that are going to be the most likely to have someone argue that as a defense for infringement. And again, that's the, remember, merger is technically a defense. So Wizards would be like, I'm going to sue you because you've infringed on my copyright. And you'd be like, nah, man, you don't have any copyright protection in that because you've got, this is a merger issue. I don't know that you want to be in that position to make that argument. If you do, good for you. And I don't think merger would actually happen as much as people want it to. Right? And I don't think it's achieved, you know, none of this is achieved secondary meaning. None of this is achieved, you know, you can think of different ways to say that same sentence over and over again. And in fact, many of us who are GMs who have started playing with new players and are teaching new players how to play the game, we've probably said that sentence 50 billion different ways, right? To explain that same concept to new players, depending on who's listening. So I think right there is an argument against merger, but I'm pretty sure, you know, but what's being put into this Creative Commons is the most content that somebody could say would be subject to merger. Whether it's true or not is an entirely separate conversation. So again, very limited amount of information going into the Creative Commons. And no statement of royalty free in this license anywhere. Hi. I see you, Wizards. And this is why you have an attorney read every contract. What you own. Your licensed work are yours. They may not be copied or used without your permission. You acknowledge that we and our licensees, as content creators ourselves, might independently come up with content similar to something you create. If you have a claim that we breached this provision or one of our licensees did in connection with content, they are licensed from us. Here's an interesting thing. This is a very interesting thing that is in the OGL, or it's in this version of the OGL. It is not in the DM's Guild. Anything you put on the DM's Guild is immediately subject to, hi, Wizards can take that and do what they want with it. They'll pay you for it, but they're going to do it. And anyone else who publishes on the DM's Guild can also use that content. So creators who are like, I need to protect my idea and all of my things, it's like, yeah, but I don't remember this fervor blowing up around the creation of the DM's Guild, y'all. Yes, this is my Fisher House Foundation mug. They're very good people. We support them. So if you have a claim that we breached the provision, any such claim will be brought only as a lawsuit for breach of contract. Okay, so you're being forced to say it's not a copyright or action, it's a breach of contract action. That's a very important point here, because your remedy under the law for it being a breach of contract is going to be different than your remedy under the law if it was copyright infringement. By saying that you are going to be forced to shift this from copyright to breach of contract means that if you get damages, it will be damages to put you in as good a position as if you were, if the contract was not breached, or at most you might get special performance of getting Wizards to not be able to sell the thing, but you can't sue them for infringing on your copyright, is what this is saying. You may expressly agree that money damages are adequate remedy for such a breach, and you will not seek or entitled to it. Oh, even better. I'm sorry, I didn't finish reading the sentence. So breach of contract and only for money damages, which means you won't be able to force them to stop publishing the thing. You will only be entitled to the amount of money that you would have made if the contract hadn't been breached, which I don't know how. I don't know where the math on that would be, because ideally in a breach of contract, right? So contract 101, if a contract is breached, let's say somebody doesn't, I am Ford and I'm going to sell a car. And we're going to sell the car to, we're going to sell the car to Joe Schmo, right? And we've signed a contract, and Joe Schmo is going to pay us $50,000 for this car, and we're going to give them the car. Well, they come, they take the car, but they don't give us any money. In a breach of contract, you would sue them, and you would only get what is called the expectation damages, the amount of money that you would have expected to receive if the other party had not breached the contract. In this case, $50,000. But there is no expectation of financial gain between you, a content creator, and Wizards of the Coast for this license, right? You're not paying them for the license. They are offering the license available, so you're not paying them for the license. You might have to pay a royalty on things that are created, but that's a over here point. So you're not paying them for the license, they're just offering you the license. So if they are in breach of the contract, you're not going to get expectation damages. There is no expectation that you're going to make any particular amount of money, particularly from them. So you would have to get punitive damages, and there are much stricter levels of punitive damages and breach of contract claims across the country. And it depends where they choose of what they call the forum selection, where the contract determines, or in this case, the license determines that you will be bound by law to litigate this particular case. In the original OGL, it specifies that they're in the state of Washington, and that you will be bound by, where is it? You'll be bound by the laws of the state of Washington and litigate anywhere, only in the state of Washington. Fine. So Unstable Dios asks, so if I am a Wizards of the Coast and there is a good work created by a small creator who has a small audience, and I, Wizards, take it and publish it to a much larger audience, is the amount I owe the creator based on their audience or mine. Yeah, so it does specify the state of Washington, which is fine, which is what I thought, because it is basically the same thing, and they would choose to have the same thing because they are a corporate entity in the state of Washington, and there's a lot of reasons why that'll be beneficial to them. But, so, Unstable Dios, the expectation is what you would have received by the other party not breaching the contract. So, the expectation would be the argument could be made about what particular amount of money you as a creator would have expected to make, maybe. And yeah, Unstable Dios. So the number here is going to be very, very fluctuated. It'll be very hard to prove. There'd be a lot of math involved. Contract lawsuits are, particularly for when you get to the damages settlement section, are a lot of math. I have sitting over here off screen, you can't see it, but it's sitting over here, is my contracts book. And specifically, there's a whole section about the math of contracts and what you get. And there's also what could be argued are reliance damages. So expectation damages are what would put you back into the position you would have been at if the other party had not breached, right? Like what you expected to get out of this contract. And because you're a third-party creator who maybe, has published one thing on DMs, published one thing ever in your life, you can't necessarily prove easily what they, you're never going to go up to a court and be able to have paperwork to show and say, hi, I expected to make $50,000 in sales. That's not going to happen, right? Like, I can't do that. But I can turn around and say, like, well, based on other products that I have worked on, I could say maybe I could expect $1,000 in sales. But again, expectation damages and reliance damages are a math equation in and of themselves. And because you're not going to be allowed injunctive relief, you can't stop them from continuing to publish the thing. And because they're arguing that that you're only going to be allowed to sue for breach of contract, you can't sue for copyright infringement, which would also allow you to gain injunctive relief and prevent them from publishing the thing, or requiring them to pay you royalties for the creation of the thing. So that right there is interesting. In any lawsuit, you must show that we knowingly and intentionally, copied your licensed work, and access and substantial similarity will not be enough to prove a breach of this section 3. There you go. Here is a sentence and a clause that could be very easily overlooked by a lot of people. And given people's fervor online about things and what they're getting all upset about is, I'm quite sure, a number of people overlooked. Yes, Ice Bunny, I'm looking at the current draft version of the newest OGL, and we're talking about the way it would work. So in any lawsuit that you bring you believe that Wizards of the Coast copied your idea and your expression of that idea, you have to prove that they knew and intentionally copied. Now, a number of creators, I'm going to cite another publisher because they're really great and they're really great about being upfront about this, like Artel Saurian, have a thing in their, for example, Artel Saurian Games has a channel in their Discord related to homebrew content for Witcher, homebrew content for Mechton, homebrew content for Cyberpunk Red. But that doesn't count as the entity of, according to the law, would not constitute as the entity of Artel Saurian Games knowing about that homebrew content. Instead, you would have to send a version of that homebrew content to Artel Saurian in either the personage of Jay Gray or Lisa Pondsmith or Cody Pondsmith or Mike Pondsmith, and then prove that they opened it, read it, and therefore they knew about it. Which is why they will be straight up and tell you nobody from Artel Saurian will comment on those homebrew channels because they can't be seen as giving you commentary, because that would prove that they know something. So even if it comes out later that they did maybe create something that could be similar to yours, you can't prove that they knew about it in advance, which is entirely fine and very, very cool that they are going to that level of control to make sure that there is equal parties are being protected under the law. This is saying you have to prove that they knowingly and intentionally, not just that they knew about it and therefore may have influenced their ideas, that you could prove. Proving knowledge is a whole hell of a lot easier than proving intention. Like, I can prove knowledge by saying, hey, I got a comment on my blog post from the official Twitter for D&D. That could prove knowledge, right? I'm not saying it is, and I'm not saying that could be considered evidence of proving knowledge. Now you have to prove intentionality. That's going to be a massive pain in the ass, because you have to then prove, you would then need a level of discovery to know exactly what individuals were thinking, and to do that you need to provide documentation that they have created of their own documentation. You'd need to have basically a email from them inside their, behind their firewall that said, hey, I saw this thing. I think it's really cool. We should take this and publish it ourselves. That's very expensive. Litigation at that level is very expensive. Now, discovery in the United States would require them to turn over any documentation that is relevant within the scope of the lawsuit, that is not unduly burdensome, that is not protected by attorney-client privilege or attorney work product. Either one of those things you can't touch. However, to do that, you have to get to the point of a lawsuit and to a point of discovery, which means your claim will have to survive a 12b6 motion to dismiss. Which means your claim would have to be good. You'd have to have enough evidence outside of that to prove of intentionality. And with this clause in here, I don't know that you could. I honestly don't. And it'll cost a whole lot of money to get to that point. And given the fact that they're saying you could only sue for breach of contract and not copyright infringement, you're not going to get a whole lot of money back. So this is an interesting point that I haven't seen a lot of people been discussing. Now, limiting how you can sue in a form agreement like this, that's not uncommon. You'll see it all the time with, a TOS, right? Like any, I don't like this song. We're just going to skip this one. There we go. But you see it all the time on any TOS. You see it anytime in your insurance policy documents. You agree to be bound by the laws of X state. You agree that you forego the right to a trial by jury and will go for an arbitration, or you'll forego the right to a trial by jury and agree to a bench trial. All of those are standard, and where a large number of people who are not attorneys might feel that that's a negative, if you actually look at why most of those end up there, it's for financial reasons and for speed. Jury trials are very, very slow and very, very expensive. Bench trials are a lot faster and usually a lot less expensive, because you don't have to worry about getting a jury and sitting there in testimony and all of that things. All you need to worry about is the judge, and usually those things get scheduled a lot faster in the courts. Now, they're still going to take a while, but they're usually faster. Arbitration is another normal standard clause in such a thing. You waive your right to a trial and instead you agree to arbitration, and where an arbiter is going to, a third party arbiter is going to agree to this. You agree to be bound by certain laws based on where you are, that we're going to be bound by the laws of the state of Washington. We agree to the forum of the case being tried in the federal court, in Washington, whatever. All of that is standard. The fact that you agree to show both knowing and intentionally licensed copied your work is wow. And that you can't, and that use of that proving that it's saying Now, this is really interesting. This statement right here, I have serious concerns with. I have serious concerns with this statement of access and substantial similarity will not be enough to prove a breach of this section 3. Because usually this is what we call how to phrase this for everyone. So in a lawsuit, in a civil lawsuit, or even in a criminal case, there are what we call the triers of fact, and there are the arbiters of law. The judge in the courtroom, if it is a jury trial, is the arbiter of law, which means he or she or they make rulings on what the law is, how it's applied, how this particular piece of evidence can be admitted or not based on the standard of the law. And it is the trier of fact in most jury trials, the jury, and in bench trials, it will also be the judge, to determine the truthfulness of a piece of evidence, what the facts of the case actually are. Like, I will come in and present my opinion and story and belief about a thing, and the other side is going to present their opinion, story, and belief about a thing, and it is the jury or the judge who is the trier of fact to determine what are the facts of the thing. This sentence is basically saying that you are agreeing that the trier of fact, the jury, the judge, whoever it is, will not be allowed to agree that they knew a thing just by you providing evidence that you had access and that the thing is substantially similar. That means you have to prove, you would have to have this high level of discovery, you would have to have documentation proof, you'd have to have some sort of additional proof to go with all of this discussion of access to show that they both knew and intended to copy the existing thing. I honestly can't think of a license or a contract where I have seen a clause like this before. Now, that does not mean that they do not exist. We have said this before, that I am not currently a practicing attorney. I am a law student and a legal intern. And I have not read, and no lawyer has read everything. But I have never seen this before. Wow, that burden of proof jumped like 6 degrees. So Ice Bunny asks, is there a difference who the fact finder is when there's a civil or criminal case? No. The only difference between whether they're a civil case or a criminal case does not matter. The trier of fact is either the jury, if there is one. If there is not a jury and it is a bench trial, then the trier of fact is also the judge, who will also be the arbiter of law. There are a lot of reasons why people would choose a bench trial. Speed, cost effectiveness, it gets things through the court much faster. All of these are valid, but you could have a trier of fact, you know, and the trier of fact is the one who determines the facts of the case, right? Like, we as the trier of fact determine that, yes, he did know and he did copy this work, and we say so because that we are the trier of fact and we agree that the evidence presented showed that. This clause is basically saying the trier of the burden has shifted substantially to a raised point. Yeah, so in Europe, in the US, ice spending is the same thing. It's 12 usually 12, although civil cases you can use 6. Criminal cases, it has to be 12. Federal cases, federal criminal cases, it has to be 12. But civil cases in the United States, it can be 6, and usually 2 alternates. Or you can, in Europe, you can also have a smaller system, but there's also there are a lot of very different legal systems in Europe, Ice Bunny, that are not all the same. This is when we talk about this, I'm talking specifically about American law, which, for people who are international who are watching this, hi, thank you very much. I appreciate each and every one of you. And if you are watching this on YouTube, hi, could you click that buttons underneath you where you like, share, and subscribe, all of the information? Thank you very much. But it is, because Wizards of the Coast is an American corporation, and this license is going to be licensed under American law. By using this license, you're agreeing to be bound by American law, and any disagreement will occur in the state of Washington in the United States using the state of Washington's laws, unless there's an argument to be made and proof to be offered about a reason why you could remove it to federal court. To be fair, the most obvious reason why you would remove it to federal court is called diversity of jurisdiction, where it means multiple people across state lines or even international lines, and therefore becomes the jurisdiction of the federal court. But that's a separate issue and a separate discussion. This sentence shifts the burden substantially. Massively substantially. Washington State, Ice Bunny. It would... You don't necessarily need to... if you are someone from Europe and you are suing them for a breach of contract, remembering, of course, that they're saying you can't sue them for copyright infringement, which would have had a much bigger financial damages and equitable performance, being injunctive relief, forcing them to not create the thing. If you're from Europe and or outside the United States in any way, if you file a lawsuit against them in the state of Washington, or in the federal courts in the District of Washington, state, not DC, you either have to go yourself or you have to have an attorney in the United States who is licensed to work in that state, who can serve as your representative in the court. Yeah, it would be a pain in the butt. It's part of the reason a large number of these major corporations also pick a particular state or place where they are located so that they can make it easier for them if there's ever a lawsuit. They aren't caring about who they're not making the people who are making claims against them lives easier. No, they're making their lives easier. All right. Well, that's a fun conversation we just had. I don't like this. I will be straightforward and honest. I do not like this section. So section 4, what we own. We own our licensed content and reserve all rights not expressly granted in this license. Yeah, okay. So basically, yeah, and I haven't even looked at the VTT yet. But there's only like 4 more sections here, and which is good because that's what a license should be. It should be very straightforward. Yeah, okay, so we're telling you what we're licensing. If we haven't agreed to license it, then it's not licensed, and we're protecting our rights to do whatever else we want with it. Fine, it's your product, it's your thing, you can do what you want. That makes sense to me. You can make so you control your content. You can make your content available under any terms you choose, but you may not change the terms under which we make our licensed content available. Okay, so that actually makes sense. I heard some people complaining about this, and I was like, okay, so you're not a lawyer. I want to double check. This is basically saying, what this is effectively saying is that Wizards is preventing sub-licensing. So you can do what you want with your own original content, but any content you used from Wizards of the Coast is still under the limits of their license, and anyone who, you license your content to has to agree to the terms of Wizards' license to use the portion of your content that came from Wizards. That makes sense. That's actually not uncommon. That's a control, that's a point of like, okay, we want to limit downstream changes. Yeah, exactly. You must clearly indicate that your licensed work contains our licensed copyright under this license, either by including the full text of this license in your licensed work or by applying a creative products badge. That actually makes things easier. Which means instead of previously where you had to recreate the license and put the whole copyright claim for the license in your work, all you have to do now is put the creator badge on. And by putting the creator badge on, you're basically saying it's under this license. I'm putting a stamp on this. This stamp tells me it's part of this thing. That makes sense. There's nothing wrong with that. Yeah, exactly. It's like as Hawkeye says, it's like a landlord banning subletting. Or, more accurately, if you do sublet, whoever you sublet to needs to agree to the same rules as you did when you had that rent, because that's what the license is for. You may permit the use of your content on any terms you want. However, if any license you offer to your licensed work is different from the terms of this license, you must include in the licensed work the attribution of our license found in the preamble of the applicable SRD and make clear that our licensed content included in your licensed work is made available. Okay, yeah. So this is, because again, if I am creating a thing, right? I'm creating an adventure for 5th edition Dungeons and Dragons, and I used SRD material under this license in that adventure. And then I want to, say, create an animated, or recreate it and license it in a different way. Like I want to license it into a printed book to another person who's putting together, let's say, an anthology. And I want to license them, like, my content. That's fine. I just also have to include the fact that Wizards Coast is included in this, and that that this is the license that is being used for Wizards content. Like, there's nothing wrong with that. This makes no sense. This makes total sense. There is nothing in all of Section 5 I have complaints about. Okay, so now we're into 6 and 7. These are going to be pretty standard, actually, contract terms. Warranties and disclaimers. You represent and warrant that you're over the age of majority, or if younger, you have had... Okay, again, this is... All of these are going to be A, B, C, D, and E. This is pretty standard contract language. Because you are making... right, like... Wizards is offering this license out into the world to anybody to use, but the use of that license means that you're agreeing to this contract. And because it is a contract, you have to make sure that it is still a legal and valid contract. You cannot make a contract with a minor. Sorry, it doesn't work. You can make a contract with a minor with a parent, with parental or guardian consent. And you have to agree to them all, and that's what that's saying. You also have to be someone, when they say authority, you have the power and authority to enter into this license and performance obligations. That's very generic terminology, a very, very standard, normal, contract language that basically says there's no legal impediment why you can't engage in this. It's less of a problem for something like this where it's being offered to a public in public for your own creation and your own content. It's more, would be seen more frequently in like buying a car, right? Like you have the power to, like, you and your spouse are jointly buying a house, but you're the person who's there signing the final piece of paper. That's basically saying that you have the power and authority to sign this piece of paper for you and or your spouse to buy this house. So Ice Bunny asks, does 6A mean if you're underage and the parental unit says no, they can grab your things? No, that means that you just aren't allowed to recreate it, and it's not licensed material, and therefore they will terminate it and force you to not use it. And a guardian would mean anyone who is considered the guardian for a minor. That can be biological parent, that can be foster parent, that can be adoptive parent. It could be a guardian ad litem. It's usually not the social worker in the United States. It wouldn't be the social worker themselves. There's usually a social worker is not considered the guardian of a minor child unless they are considered an emergency guardian and they need to intervene, in which case they would remove the child from a harmful situation, and they are only the guardian for that child for the duration of removal of them from that harmful situation to a better, more safe situation. It's just like how teachers can be temporary guardians while the minor child is on the property of the school. But that doesn't mean that they can actually, it means that, so a minor, you know, like a teacher, if there is an accident on, like when I was coaching and teaching, and we were at a game, right, an away game, and one of the kids, you know, we're playing soccer, and one of the kids gets a soccer ball to the face and breaks their nose, I can go with the child to an emergency room and sign documents to allow the child to be treated, basically give permission for the child to be treated, and I would stay until the parent or actual guardian arrives, and I would shift, I was only the guardian for that limited amount of time, long enough for the child to receive treatment or begin treatment while the actual guardian arrives. So in this case, it would be the parent or any actual guardian, the guardian ad litem. It doesn't matter if you continue to do that. If you basically, however, this clause runs into the same problem every TOS clause runs into online, right? YouTube, looking at you. You know, you can't agree, a minor can't agree to a TOS because it's a contract. How many of us know of individuals who were under the age of 18 when they clicked on a thing on a TOS box and said, hey, I would like to access this website, access this content? Are you over the age of 18? Yes, totally. Oh, see, Ice Bunny, what you're talking about is, that's different, right? Like, the social worker would be, what you're saying. So Ice Bunny says, I know a case from Germany where the parents wanted to buy a house for a kid under 18 and they had to deal with the equivalent of CPS in court. So I'm betting there are other factors involved in that, where the social worker looked at this and go, why are the parents buying the minor child a house? Right? Like, is everyone supposed to be living there? Are you buying a house for your minor child where you will not be living as well? That would just raise a lot of red flags for social workers to investigate, but that isn't necessarily the same thing as having your parent say, no, you can't do this thing, or play, you know, you can't verify you're over the age of 18 or click this box, and therefore you can go and watch the thing. That's not what this means. This clause is much more similar to if you are of a certain age. You might remember a thing called Neopets. And you might remember where because it had a website, if you were of a certain age, you could have your parents sign a form and you would fax it to a phone number to get access to the website. So Unstable Dios asks, isn't 13 the minimum for certain areas online though, or is that a separate concept from this clause? So that's technically a separate concept from this clause. The 13-year-old minimum is for access to websites. And that's not the same thing as agreeing to actually make a contract with a minor. The 13-year-old minimum is about the Online Children Protection Act. I forget the name of it, but that is basically what it means. It's basically what it is. And it's all about minor children accessing content online that they should not be doing so. It's why you have like YouTube Kids versus, and I can access, 13-year-olds can now access YouTube, other things. This is about making a contract. This is about signing a TOS. This is about, performing an action. And a minor can still do that with parental consent, or guardian consent. And that's what this clause is basically saying. It's basically you're saying, you agree that you're over the age of majority, which is in the United States, the age of 18. Or if you were younger, you've had your parent review or guardian review these terms and agree to them on your behalf, which basically means you can continue to do this. You can do this if you're under the age of 18. You can make this, but you've got to have parental consent. And because of the way this document is set up, and if you are under the age of 18 and you publish an adventure for D&D 5th edition, then you are effectively saying, I'm bound by the terms of this license, and therefore I am agreeing to the concept that my parent or guardian has reviewed these and agreed that you agree to them. So that the parent or guardian can't come back later and say, we're suing you for X reason. Well, according to using this license, your minor child stated that you knew about this, and now I've got to prove that you didn't. Okay, I don't like this one. I don't like screeching. Okay. There we go. So, no infringement. Your licensed works do not and will not infringe any third party's intellectual property rights and or any of our rights not listed to you via this license. This is straightforward. You can't copy anyone else's work. Hi. You're only allowed to use what we are allowing you to use under the license. You can't take anything else. You can't copy from some Kobold Press. You can't copy from Paizo. Hi. Except as otherwise expressly allowed by this license, you will not state, suggest, or imply that your licensed work is endorsed or associated with us. Again, very straightforward, which is why I also think that they went to the badge system. It means that there's now a very specific image that is connected to the original trademark, but is not the original trademark, and therefore you can make a distinction visually and mentally within the consumer that it's not necessarily going to be endorsed. Okay, so I saw this earlier online, and I was like, yo, you can't be really this hyperbolic, y'all. No illegal content. You will not violate the law in any way relating to this license. Hi. Or your licensed work. Relating to this license or this licensed work. That's not you can't violate the law, which I hope you're not. This is not me endorsing you violating the law. This is also me not saying, again, not legal advice. You will not violate the law as it relates to this particular license or your content that you're tying this license to. That means, hey, you can't do anything with this license that would be inherently breaking the law. And realistically, the number one thing what this is basically doing, and I'm pretty much guarantee that this is a reason why they did this, is this is your anti-child porn clause. This is what that is. Now, I don't know any reason why anyone would want to use, I don't support that in any way, shape, or form. Please don't, and I don't want to know anything about that. But basically, this is a clause that would say the minute you're not allowed to use anything related to this license to break the law. Your content can't break the law. And if you put our content in a thing where you're breaking the law, then this license is terminated, is basically what they're saying. And they will probably sue you after you get arrested. But there were people online who were like, well, I can't get a parking ticket. And I'm like, that's not what this says. Yo, as related to the license. Anyway, relating to this license. I love the internet some days, don't you? No hate. This is a bigger concern, however. No hateful content or conduct. You will not include content in your licensed works that is harmful, discriminatory, illegal, obscene, or harassing, or engage in any contact that is harmful, discriminatory, illegal, obscene, or harassing. We have the sole right to decide what conduct or content is hateful, and your covenant that you will not contest any such determination via any suit or any legal action. No book of erotic fantasy. I mean, probably. This is they get to determine. So on one hand, yes, this clause is very... This clause is very much a... open-ended, ambiguous statement. They're not providing you a definition for any of these terms. They're saying that they reserve the sole right to determine what is hateful, if what it meets any of that, and you can't contest in any way, shape, or form that determination. Oh no, Jer, you can. Because that's not part of the license. What this is saying, here's where things get going. As Jer was saying, sarcastically, I'm assuming, I can't write my Driss /fic now. No, you can, because that would not be released using the SRD content, because it's a /fic and not the same thing, and Driss isn't covered by the OGL anyways. Driss is part of the Forgotten Realms, and the Heroes of the Hall are also not covered by this document. That would be under the SRD. Or not under the SRD, under the DM's Guild. Sorry, that is my misspoke. It would be under the DM's Guild, not this document in anyways. But it would be a fic, and therefore, A, not something you're releasing as part of a game material. And therefore wouldn't be covered by this. Yeah, Hawkeye, it's very ambiguous, but at the same time, it is very ambiguous, and I personally would prefer some clarity and more clear. Yes, you can't write your Big B's Hand erotic campaign. Please, why did... And so... Here's the thing, it is very ambiguous. It is subject to a lot of interpretation, but anybody who creates a license for their own intellectual property has the right to determine and limit who uses their intellectual property. So they can be as arbitrary as they want. It's their property. It's their sandbox. they're inviting you into it. They can kick you out at any time they want. They can just say, I don't like you. And they don't even need to prove why. There is no discrimination protection about this. This is just, we think that this is hateful and we're going to get rid of it. And you. They can do that. It's a thing that they can do. It's their property. So Unstable Dios says, is the jurisdiction for 6E the state of Washington, so the legality in and morality of the state of Washington is being applied to the entire planet, even if the content would be allowed in, say, Europe, or 6F, sorry. So 6E, the illegal conduct is going to be, again. So in this case, the illegal content, so both the hateful content and the illegal conduct, they don't need to provide a jurisdiction for what they determine as hateful content under 6F, because it is them, Wizards of the Coast, who have the final arbiter. It is not any one country, nation, county, state, none of that. It's not bound by statute. It is bound by what Wizards of the Coast consider to be hateful conduct. The illegal conduct, is because of the rest of this whole law is written and bound by the laws of the state of Washington. Yes, by agreeing to these terms, by agreeing to this license, you're being bound by the state of Washington. And if a thing is illegal in the state of Washington, regardless of how legal it is in, say, Amsterdam, you can't do that. Which could be a problem for, countries and states that have different ages of consent. And this is why I very firmly stick on the, please stick to So Faison says, was talking about this earlier, not sure if you covered it. Generally think it's a good provision. Yeah, exactly. It is a good provision. I generally think it's a good provision. And generally it's a provision that you would have in any contract, right? Like if it's any licensing contract, would include the licensor's right to review how you use the licensed materials and determine whether they agree with the use of the licensed materials and they meet within their standards, right? Like that's just a general, that's what this is. They're being more specific about it being hateful conduct and that they're the final arbiter about what hateful conduct is. I don't know that it should be, I would prefer, given how they've defined everything else, I think that they should put a little bit more either clarity and definition or example in what they're determining that is, but it definitely falls into the age-old clause of I'll know it when I see it. Yeah, there are some valid concerns. It would mean that you could, it also limits, like, okay, what are you, like the discriminatory, harassing, those are, discriminatory and harassing, those are pretty standard translation. And illegal. Like, those three are very straightforward, that's fine. It's the obscene or harmful. I don't agree with that. Like, I don't agree with that. Also, Faye, we are definitely in the high. I really don't like this, this clause in section 3 here, where you're A, going to be forced to sue for breach of contract instead of copyright infringement, and B, you have to prove intentionality, knowing and intentionality, to prove a breach of contract rather than just access and substantial similarity. I'm like, yo, you're shifting. I didn't know that in a licensing agreement you could shift the burden of proof. I was pretty sure that that was a statutory issue. But yeah, Faison is I was like, that's how many lawsuits. But that's the thing is, like, yeah, for that to make it in. You acknowledge that we and our licensees as content creators ourselves might independently come up with content similar to something you create. If you have a claim that we've breached this provision, you can only sue for breach of contract, and only for money damages in a breach of contract, not for injunctive relief, and not for infringement. So you're SOL. Particularly given this burden of proof standard that they forced in here, which we'll pay you if you can prove it, but we won't stop. A, but B, you could, because of the fact it's breach of contract damages and not copyright infringement damages, there's no punitive damages associated with that, very rarely, and I don't believe that Washington allows for punitive damages in breach of contract, but I would have to double check, and I am not an attorney licensed in the state of Washington, so do not at me with that. I said I would have to double check. There could be legitimately no expectation damages on this. If you are a small enough creator that you are expecting maybe 5 to 10 units sold, that you would have no there would be no damages here. Exactly, Faye. Faye says, I'm somewhat surprised that they're not trying to force arbitration. I'm actually more surprised that this isn't about arbitration. Like, usually arbitration agreements and licensing agreements or contracts or TOS or your insurance policies are extremely common. Like, we talked about that. Having a arbitration agreement, forced arbitration agreement, which those are a lot easier to get it wrong than people think, is so common. But this shifting of standard of burden of proof, that is, I don't like that. I don't like that. I don't like the phrasing here with obscene and harmful. I think those need to be defined or taken out of this. I also don't think that this is actually enforceable. I would have to research the laws of the state of Washington, but in certain states I can think of, this is not enforceable. Like, you will not contest any determination via any suit or any legal action. Like, lawsuit, that could be enforceable, but any other legal action, like an injunction or an arbitration or a mediation, I don't think that part is enforceable. I don't think you can, like, that I don't think you can enforce. I think they could get away with saying that you cannot contest their determination of what is or is not harmful or hateful, based on lawsuit. That I agree with. But I don't think that, the arbitration. But here's the thing, Faye. One thing that this does include, right down here, Section 9D, severability clause. This did not exist in the draft version we looked at of the leaked version of the 1.1. It did not include a severability clause. Severability clauses are very important. Severability clauses, this is, again, very standard contract language, very standard acceptance. If any part of this license is held to be unenforceable or invalid for any reasons, Wizards may declare the entire license void, either as between it and the party that obtained the ruling or in its entirety. Unless the Wizards elects to do so, the balance of this license will be enforced as if that part which is unenforceable or is invalid did not exist. So basically, this clause means that, oh hey, if a court says that this that this clause is invalid, that this burden of proof clause is invalid, well, we can just take that from the license and it won't invalidate the rest of the license. Which is pretty standard, right? Like, it's the amount of time, effort, and hours that go into a contract negotiation and writing and drafting. Like, the research, the drafting, the approvals of the draft, the rewrites of the draft, look, you could have associates spend weeks on this and have massive amounts of money on it. And rather than rewrite the whole thing, you can just go, I'm going to clip this clause and it doesn't invalidate everything else. That's pretty standard. Yeah, one does hope so that some of the bigger players already have their lawyers poring over this. I would think so by this point. They would have to. Okay, so modification or termination. Because, see, here's the other thing, Faison. We were talking, again, I don't remember if you were here, because we were talking about the fact that the actual license itself is a perpetual, non-exclusive, and irrevocable. It is not royalty-free. It doesn't say royalty-free anywhere in this document. It is worldwide, perpetual, non-exclusive, and irrevocable, but it is not royalty-free. And see, here's the thing. It has been my experience, and I've been spending a lot of time with licensing agreements, that the courts do not like irrevocable and royalty-free. It has also been my experience that the courts really don't like perpetual, irrevocable, and royalty-free. Putting those three together, the courts are like, why you do? Either it has a time limit, in which case it's not perpetual, or it is irrevocable, but you have a royalty for it. But all three, the courts don't usually like. I want to this, and again, this is a draft. I fully expect that there will be a modifications to this before we get to the end. But this is just my experience. Again, I am not every lawyer, and it depends is a very important thing. And that each individual, like we said before, you could ask 5 different attorneys to look at this document and get 8 different answers. All right, so we may only modify the provisions of this license identifying the attribution required under Section 5 and the notice provision in Section 9A. We may not modify any other provision. That's interesting. Yeah, well, their answer will depend on their client primarily. This is true. What does the client want? Well, I can make that happen. This is very interesting, particularly when it goes with the severability clause that exists. This seems really great on its face, but it's waving some, it's tingling the back of my mind, right? Like, you can only modify the provisions of this license identifying the attribution required under Section 5 and the notice provision under Section 9A. And they may not modify any other provision. However, there is a severability clause. Now, admittedly, if you have to sever a clause, it isn't really modifying about it. Yeah, but Faye, if they did mention that, and I looked at it, but I'm also looking at it going, it doesn't matter what they say in their statement. I'm thinking about it from a four corners, right? Like, their statement wouldn't be admitted as extrinsic parole evidence. Only the bounds of the contract, if this was the final draft of the contract. I don't like that terminology. I think we might see some changing in the phrasing of that statement, and how it works. So this will be very interesting. They may not modify, but they may terminate your license if you infringe on the intellectual property, bring an action challenging our ownership of the content, trademarks, patents. Again, that's pretty standard. If you agree to the license, you cannot then turn around and say that the license is invalid. You have to challenge the license before you accept the license. Otherwise, your acceptance of the license would be evidence in court. Well, you accepted the license, so why are you accepting a license for something that you don't think that they have a right to? That would be the court's position. So that's pretty standard. You can't challenge the license while you're operating under the license. And you can't violate any laws or the Section F. Fine. You can terminate. They can terminate the license if you violate the law. Basically, Section F, Section 6F, Section 6E. Or you bring an action challenging their ownership of the license content. Fine. Or you infringe on any other electronic property. I mean, like, those 4 sections are really kind of standard or really kind of nice. Legitimately, like, there's nothing wrong with that statement. We may terminate your license if you breach any other term of this license and do not cure that breach within 30 days of notice to you of the breach. Okay, so not when you should have known of the occurrence of the breach, but within 30 days of notice of the breach. Alright. That actually gives you a substantial amount of time to cure a breach. And usually if you make a good faith effort attempt to cure a breach within a set timeline, and you communicate with the other party that, the party not in breach about your attempts to cure and what needs to be done to cure, if that goes over 30 days, then usually that's not a problem. It's when you don't even attempt to cure within 30 days that would be a problem. So, like, the termination, I have no problem with. I think this is very straightforward contract language. I think this is very equitable contract language. I would accept this. Disclaimer of warranties and limitation of liability. You understand and agree that we are providing the licensed content as is and make no representation or warranty of any kind concerning your use of the licensed content except as expressly stated in the license. Yeah, again, all very standard. We have no liability to you for any types of damages in connection with your use of your licensed content, including without limitation any indirect, consequential, special, punitive, or exemplary damages, so long as our conduct at issue was not grossly negligent or intentional. This is, again, very straightforward warranty. You're accepting what the document as is. You're not challenging the validity of, like, the spell, Leomund's Tiny Hut, which, isn't part of the SRD. The Tiny Hut spell, which is part of the SRD, is as is, right? Like, it's the spell. Its math is what its math is. Don't try and mess with it. Okay, so now we get into the miscellaneous. Alright, notice. We may notify you by any email or physical address we can locate for you. Only if we cannot locate your email or physical address after a reasonable search, notice via a public channel is sufficient. You may provide notice to us of your email or physical address or any other notice by emailing. Okay, so this is normal. Like, they're basically saying, okay, we'll find your email or physical address. If we can't find your email or physical address within a short, relatively reasonable amount of time, which is probably, a couple hours of searching on Google, we will put a public notice up somewhere, and that will count as notice. Usually in a paper, it's become more and more required for, like, a national paper rather than just, say, like, the local Seattle paper, or on a platform like Twitter, or on their own website would count usually. This license governs your use of our licensed content. This license consists only of the terms expressly included herein and not any other not expressly included herein. There we go. In accepting this license, you represent and warrant to us that you have relied only on the terms of the license and the advice of your counsel, if any, and have not relied on anything not expressly as part of the license. This right here, this sentence right here, basically says, it does not matter what we put in our FRQ. It does not matter what somebody says on Twitter. It does not matter what somebody says in a video describing this that may or may not be on our channel. Only the words of the terms of this particular document are considered valid. I mean, that's basically contract law 101. Well, not 101. It's slightly more complicated than that. Parole evidence is second year. So this is them saying, you know, parole evidence won't be admitted. You agree that you are bound by the terms of this contract. It's the four corners. Yeah, but Todd Kendrick said so. Does not matter. But Sage answers, don't care. But I saw on Reddit, not a problem, not an issue. Don't even. If it's not within the bounds of the contract, it does not matter. If we fail to exercise, okay, again, this is very straightforward. Them failing to exercise a right is not a waiver of those rights, or prevent them from accessing them in the future. Again, a very standard contract term, very, very particularly in something like this. Particularly in something where it's something worldwide, right? And there's so much out there on thing that's published every day that it's probably exceedingly hard to know exactly what documents are published and where, and you know, and have somebody review them, and if they haven't found it the first time, then that might not necessarily mean, you know, that doesn't mean that they're waiving their right. It just means that they didn't find it, and when they find it, they can enforce their rights. All right. We talked about the severability clause. So I saw people getting upset about this online, right? The waiver of jury trial. We and you each waive any right to a jury trial for any dispute, claim, or cause of action related to or arising out of this license. This is not abnormal. Jury trials are expensive, time-consuming, and take forever. Forcing an agreement to a bench trial is pretty common. However, there are states that will tell you if you challenge this clause, you would win. Not all of them, because you would still be like, I've agreed to this term, and therefore, usually the aggriever, yeah, it's not an uncommon clause, but usually that waiver of a jury trial, if it goes without a state, like, here's what's interesting about it. Your waiver of a jury trial in this usually would include a requirement for arbitration. But there is no requirement for arbitration in this draft. And again, I'm reiterating, this is a draft of this version, which I find interesting. They can put it in the contract, but there are ways around that. So Ice Bunny asks, would a jury trial be better? It depends, right? Remember we talked earlier about the difference between a trier of fact and an arbiter of law. And in a bench trial where the judge, who is the only person there, is both the arbiter of fact, or is the trier of fact and the arbiter of law, they are usually less easily emotionally manipulated because they know how the law works. They've sat in these trials many, many times. You can't play on heartstrings, and you can't. There isn't a lot of theater that would go into before a judge. A jury is easier to, exactly, depending on who the people of the jury are, it can be easier to manipulate, to play on the heartstrings, or to try and play on the heartstrings of the jury to a point where it is believed that a jury is more predisposed for the little guy against the evil corporation. Those usually play better in like big multi-million class action lawsuits where you're suing like BP for poisoning groundwater and everybody's dying of leukemia. Yeah, those are usually how that works. In a case like this, where it really would be more about the law, it could go either way, right? Like, you don't have a lot of emotional points you can pull on this. The fact of the matter is that you're in a situation where there's going to be a lot of question about law rather than fact. And when you get to the point of fact, yes, the jury is more likely to side with the underdog based purely on numbers, but you can never predict a jury. Just don't even try. Like, a lawyer will tell you, never try to predict a jury. You never know what they're going to do. A judge can theoretically attempt to be predicted based on their previous rulings, but still don't even try. Yeah, and Unstable Diaz points out, jury trials with IP law get pretty messy as most jurors aren't technically competent enough to assess wrongdoing. Exactly. And IP law requires heavily on technical competency and sort of things. And so you need... This waiver of trial by jury doesn't bother me. This is not an uncommon clause, and given the subject matter of the license, I actually think it would be almost beneficial to you to have it as a bench trial, because then you're arguing the facts in front of the arbiter of law, and could be easier. Was Google versus Oracle a jury trial? I don't remember. I honestly don't remember Unstable Diaz. I would have to look it up. Faysan says, I lost my first trial. The judge was very kind and spoke with both of us after the trial. Opposing counsel was also new. And the judge told us she had no idea how I lost. But juries, exactly. You can't predict juries. You just can't. Like, a juror might come in and be like, I don't like the color tie that particular lawyer is wearing. I do not trust him. It doesn't matter that what he's saying is the God's honest truth. I don't like that tie. I don't trust him. Like, literally, I've had that. I've had to voir dire a couple jurors, and that was an entire conversation. Exactly. And all it takes is one juror to, plaintiffs' attorneys, those who do like big class action lawsuits, asbestos trials that are currently going on is a big one. They like juries. They like juries a lot because, they can play, oh, look, my poor client who is dying of mesothelioma brought on by the horrible actions of this particular corporation. Feel sorry for them. And the jury can or won't. Yeah, exactly. You are correct. Thank you, Unstable Diaz. They say that Google versus Oracle was a jury trial, and that was a freaking mess. Yes. Oh, thank you for saying I'm a likable lawyer. I appreciate that. Nice, buddy. I'm not a lawyer yet. Hopefully soon. But it is very much a point where in IP law, honestly, I would rather... Here, now this is me stepping back. This is not... I'm going to shift so that you know this is me stepping back. This is not about the Wizards of the Coast in particular. This is not about that. Any specifics. This is me saying, as an IP... As a hopeful soon-to-be IP attorney who spent a lot of time in law school focusing on IP with an IP concentration. I've taken a lot of IP courses. I would rather not have a jury trial unless it's a really... 9 times out of 10, I don't want a jury trial. There might be an exception, but 9 times out of 10, I don't want a jury trial. And honestly, I would rather rather be in the federal circuit. I'd rather be in the federal district so I can remove this case and when appeal it to the federal circuit, which is specifically about patents and IP law, and not have to deal with judges who don't know enough about IP law. And I will tell you right now that in the sliding scale, right, there's a sliding scale of nerdiness among lawyers. Over here on the least nerdy are the plaintiff's attorneys, because they need to be sociable and interact well with clients that are sick and dying, and they're basically really them and ambulance chasers. They're over here. And then on the far other side, you have the two most nerdy groups of lawyers, and they are at just one step below the most nerdy. Well, 2 steps below the most nerdy are trademark and copyright lawyers. The penultimate most nerdy are the patent attorneys, and the only people nerdier than the patent attorneys are the tax attorneys, because they're basically accountants with a law degree. Okay? I exist over here. And because of how much and specialized that is, there's a lot of court, and there's a very specialized appeal system. The federal circuit is a very particular thing. Going to the federal circuit is in an appeal is very different in a patent case or in a trademark or copyright case is very different. You have the USPTO, the United States Patent and Trademark Office, you can take the patent bar, you can take the trademark bar. We're over here, and plaintiffs' attorneys are over here. Public defenders are kind of closer to plaintiffs' attorneys, because to be a very effective long-term public defender, you have to be a bleeding heart and be able to, be willing to work with a lot of people who, yeah, I give you credit. It's not for me. But as an IP attorney, and acknowledging the fact that I am a nerd, I'm on the nerdier end of the legal spectrum, I would rather have a bench trial, and if I need to appeal immediately to the federal circuit. Okay, so I spent in the United States, you cannot get a BA in law. You can get a BA in pre-law, but to get a law degree is a Juris Doctorate, a JD. Which is a graduate level degree, a professional level degree. And it is you have to have completed your undergraduate before you go to that. Now you do have to take classes in all of the basic types of law, which is standardized by the American Bar Association, and is usually federal civil procedure, contracts, torts, property, introduction to criminal law, and then introduction to constitutional law. You'll have to take some sort of writing class. And then usually you'll get to choose something like business organizations, federal tax, evidence, commercial code. You'll be required to take an ethics course. But then there's a whole bunch of classes that you'll be allowed to take whatever you want in. So for me, I did not take trusts and estates because I didn't need to. Yeah, and I did property. I survived property. And for anyone of you out there who's wondering, and probably on YouTube skipping this section of the video, we'll go back to the D&D questions in a minute. The worst thing about oh, see, Faye, we didn't have to do professionalism hours in Connecticut. You're not required to. You have to take ethics your second year, which is just a ethics course to prepare you for the MPRE. And if you are admitted, if you do well enough on the ethics course on a Connecticut state, or in a Connecticut school, law school, of which there are only 3, if you get a C or above in the ethics course, you don't have to take the MPRE to be admitted to the Connecticut bar. And if you get, like, I believe it's a B or above, you don't have to take the MPRE to get admitted to the New York bar. But professionalism hours, we were not required to do. But we're going to go dive back into D&D. So, again, the waiver of the jury trial, that doesn't bother me. That actually, I think, would work really well with IP law. It doesn't get bogged down in the fact that there's a lot of very complicated things that can get very messy with IP law and triers of fact and arbiters of law. That's a big thing. Oh, look, you have a class action. This is again, this clause is basically the same as the existing OGL. I saw people on Twitter today complaining about, well, how can you force us to take a class action waiver? I'm like, it's in the original. It's not an uncommon, this is not an uncommon clause. It's forcing you to take the, this license in all matters relating to its interpretation and enforcement will be governed by the laws of the state of Washington. There you go. There's your forum selection and law selection clause. And any disputes arising out of or relating to this license will be resolved solely and exclusively through individual litigation in the state or federal courts located in the county in which Wizards or any successor has its headquarters, and the parties expressly consent to the jurisdiction of said courts. There you go. Forum selection. Individual cases, probably the only way that this would, by the way, fun fact, the likelihood of this case, if you sued Wizards of the Coast, unless you lived in the state of Washington, you could move for removal to the federal district in the state of Washington immediately on the basis of diversity of jurisdiction. Because unless you lived in the state of Washington, you have diversity of jurisdiction. And that might actually be better for you, or worse, who knows. You would have to determine based on the laws that exist, but you'd still be subject to the laws of individual laws of the state of Washington, except where the federal laws would supersede. Each party hereto irrevocably waives the right to participate in any class, collective, or other joint action with respect to such a dispute. I'm going to let you in on a little secret. Big old secret here. Although there are many TOS, licensing agreements, similar contracts that you will see, your insurance policy that we've talked about before, who have a you waive your right to a class or collective lawsuit clause in them. Most courts will not will not enforce that. Waiver will not be that waiver is usually not enforceable and ends up being severed. That just is the way that works. None of this here, all of Section 9 is almost boilerplate. All of this is almost boilerplate language for a licensing agreement or a contract of any sort. Oh, look, they got rid of the phrase that most angered me and concerned me in the OGL 1.1 version. This is, now it says you should seek advice of counsel to make sure you understand this license, rather than what they had in version 1.1, which was, oh, you can contact us and we'll answer any questions for you. No! Contact your own attorney and get your own attorney to read this and review it and answer questions for you. That is what you should do. Your attorney is responsible to you. They are a fiduciary to you. They have an ethical requirement to you. Someone else does not have that ethical requirement. Always check with your own attorney before you sign a document. You agree that you, and by using this license, once you start writing something using this license, you're saying that, yes, I had my attorney review it, or I had the opportunity for an attorney to review it. Okay, so by and large, I only see a couple red flags. This issue with Section 3, the fact that they don't state that it is royalty free, and the fact that the only content that's going under the Creative Commons is content that is most likely purely mechanics or merger. Those are my currently big issues, but overall it is leaps and bounds above any previous document that I'm still pretty sure was not actually written by a lawyer, instead was written by a PR person for a lawyer to review, and was probably based on their interpretation of what they had the draft of a license and what they thought it would mean. All right, so what is the VTT policy? All right, so page 6, what is the VTT policy? As gamers and big fans of VTT, we are announcing this new VTT policy as part of the rollout for OGL 1.2. Why does Wizards need a policy? Okay, we support the role VTTs play in tabletop space, the ability to game remotely, fine, and it's wonderful that people thousands of miles apart, great, but as VTTs advance, their functionality will raise tricky questions. Where's the line between a VTT and a video game? Oh, I know why this is a thing. I know why this is a problem. When does a VTT become more than just a replacement for a virtual tabletop? Those questions require thoughtful answers. Answering them will take time, and we want this policy to reflect your input. So we will be asking for feedback and talking to you about our goals as that discussion advances. Using VTTs to replicate the experience of sitting around the table with your friends. So displaying static SRD content is fine because it's just like looking at a source book. You can put the text of the magic missile up in your VTT and use it to calculate and apply damage to your target. And automating magic missiles damage to replace the manually rolling and calculating is fine. You can play magic 1d4 plus 1 automatically to your target's hits. You do not have to manually calculate. Okay. So this is basically saying I can, because again, this document and the VT policy is still focused on the actual reproduction of the text, right? What isn't permitted are features that don't replicate your dining room table storytelling. If you replace your imagination with the animation of a magic missile streaking across the board, strike a target, or your VTT integrates our content as an NFT, that's not okay. So here's the thing. So Barentor says this is what they're planning to do and don't want you doing it. Jer says the real question they're asking is what makes D&D Beyond's VTT different from any other VTTs? And the point about the fully automated, when does a virtual tabletop, when does cross between a virtual tabletop and a video game, and that's looking at one multiverse. That's what they're doing. They're looking at one multiverse or Tailspire. Here's my thing. I do not think if you replace your imagination with an animation of the magic missile streaking across the board to strike your target, or your VTT integrates our content as an NFT, that's not a tabletop experience. That's more like a video game. So the NFT, maybe. But the animation streaking across the board to strike your target, I don't know that I agree with that statement, right? Like, animated spell effects in Roll20 are not the same thing as a video game. So, honestly, and if I'm creating the animation and I'm designing what it looks like, and I am putting in the time and effort to put a spell effect on a target, that's my creation. And it can get fuzzy because technically magic missile is a copyrighted term. But under the OGL, so I can't use... Would something like Hearthstone or any other dick builders be evidence that it is like a video game? It depends, right? Like, because Hearthstone is a video game. Magic the Gathering Arena is a video game of a tabletop. I think one multiverse is one multiverse is basically a video game that you play with your friends and you're using as a DM, as a storyteller. I have lots of respect for them. I think they're doing great work. I know a bunch of people that are involved with them. This is not me ragging on them. It is basically creating a collaborative video game. But Roll20, if I want to have animated dice, if I want to have engaged lighting effects, if I want to have an animated map, none of that, unless it's of specifically Wizards of the Coast's content, and by that I mean their map reproduced from their monsterment, from their books, or as they say, you can't take an owlbear token. May I make my VTT owlbear token look like one from the monster manual? Yeah, you can't do that because they don't actually own the rights to that art. That art is still owned by the artist. So they can't license you that. That's not a thing. You can use this, you can call the creature an owlbear, you can take that image, you can have a generic token pack that you buy from Roll20, this thing that is an owlbear, but it can't look exactly like the picture in the monster manual because that particular art is probably still owned by the artist who created it, and therefore they don't have a right to license that. The only thing I'm thinking is, well, you're animating the spell effect. I don't know that you can really enforce that one. I think that this is going to be where you're going to have the most problems. No, I don't. God, no, I don't. This statement right here. See, Hearthstone gets fuzzy because Hearthstone was created as a video game. It is defined as a video game. A virtual tabletop isn't actually a virtual tabletop. It isn't a video game. It is a virtual tabletop, which is a connection for everybody who's there. It just happens to have certain animated effects. Right? Like, if you're a VTT owner or operator who supports the OGL products on your platform, you have the same obligations for VTT content that any other website owner or operator has for copyrighted content under the DMCA. No, you don't. The DMCA has nothing to do, absolutely nothing to do with Wizards of the Coast. Let me rephrase that. has nothing to do with Wizards of the Coast's published materials under the OGL, the SRD, in the Monster Manual, in the Player's Handbook, or even in the DM's Guide. The DMCA is the Digital Music Copyright Act. Now, it's also been expanded to include video and other things, but you cannot DMCA. You can't DMCA a written word. Like, according to their argument, this whole discussion of a published document would be considered in violation of the DMCA, and it's not. I'm sorry, what? No. No. Like, again, it depends, and there will frequently be points where I will say it depends, but this particular clause right here, no. Yeah, so Barontor, what they're trying to... Barontor says, are they trying to draw an equivalency from VTTs to something like YouTube? Yes. And what they're trying to say is that the VTT is a platform and so has the same protections and rights as YouTube does as a platform. It is like Roll20, for example. Roll20, and here's the thing, unless you're streaming, none of this matters, right? Like, unless you're streaming, none of this matters. But if I'm on Roll20 and I'm playing music on Roll20 to my players, Digital Millennium Copyright Act, sorry, Digital Millennium Copyright Act, but yes, it has to do with music. Wow, I misspoke. That is my bad. I will fully take it all in the comments. I fully understand. I misspoke. But there is nothing in the Digital Millennium Copyright Act that would protect this document in any way, shape, or form from being recreated. Like, I have to give attribution, and I am referencing it and reviewing it, but it's also a publicly available document, and anyone can go and pick it up anywhere they want. I can't record... I can't show you visual medium. I can't show you auditory medium. There's nothing... Roll20 is a website, not a platform. Well, it is a platform. We would consider it a platform, but it's not legally a platform. It's not like YouTube or Twitch. I don't know that they have the same safe harbor protections under the DMCA. Wow, I'm still mad at myself for that one. I should know better. But this is still not the same thing, right? Like, you have to... Yeah, exactly. Map Tool is a platform, but not a website. Exactly. But Roll20 is a website. And it is a virtual tabletop. And now, mind you, this whole thing is entirely disingenuous because Roll20 has its own licensing agreements with Wizards of the Coast. They have to because they have the other Roll20 marketplace where they sell Roll20 PDFs. Or they sell Dungeons & Dragons PDFs. Is an integrated document. So Roll20, I believe, the Foundry, what is it? Why am I blanking on? The other two are all have their own licensing agreements with Dungeons & Dragons. Having them operate under a VTT policy is not the same thing as them already having their own existing rights. Fantasy Grounds, thank you, Unstable Dios, Fantasy Grounds. And this is basically saying that any non-streamed game that happens on Roll20 that happens to have a reproduction of copyrighted material, which gets fuzzy already because Roll20 isn't responsible for like Roll20 doesn't go into each individual game to see who's uploaded what as a PDF for their players. And by forcing them to now do so, you're impeding the fact that it's a virtual tabletop. Like, the argument about whether or not animating Magic Missile changes its form and you can operate changes it to a video game from instead of a tabletop experience, and therefore it becomes a new medium that requires a different licensing agreement. That assumes that, okay, but what if I go to play at my local game store, right? Like, I'm playing at my local game. According to this, if I play at my local game store and I share books with other players at the table, I'd be violating their copyright, according to this. Because I'm assuming that 90% of the people who play on things like Fantasy Grounds, Roll20, they don't stream their games. 99% of them. Welcome in, Malk. No, they're not quite as bad, but some of their current issues are special. Like, this doesn't make sense. It just doesn't. I don't know how you would enforce this. I don't believe that there is any, like, I don't know that you can enforce this. The one multiverse thing about the question about whether or not one multiverse functions as a virtual tabletop or as a video game, and therefore would require a different license to recreate things in a new medium, that's a legitimate question that I don't have a full answer to. So Unstable Dios, the question is, Unstable Dios asks a property question then. Do I own a PDF or not? I know I own a physical book, yes. But do I own or subscribe to a PDF through a service? So here's the thing. If you can download the PDF so it is in a means that you and only you can control, then you own it. Right? Like, if you can download the PDF onto your own hard drive, then you own it. If your only access to that PDF is online through a subscription service, well, then it's like Steam and PlayStation and all these new game systems where the question of your own protection and rights is you do own it, but whether or not you have access to it because, or even more, like, if you subscribe to HBO Max and you were one of those people who are like, oh, well, I really like this TV series and now it's not there. So Unstable Dios, the right to resell a downloaded PDF is limited to the same rights you would have in selling an individual copy of a book. You can only sell like one copy of the PDF, and ideally this would actually be subject to the DMCA, right? This question is actually subject to the DMCA. You cannot reproduce multiple copies of it and sell it for whatever. You can make a small amount of copies and give them away. You can sell a physical a physical object, but you can't make multiple copies of the PDF that you've downloaded and sell those. It's like making copies of you can't download music and then download MP4 files, MP3 files, and then just make mixtapes and sell that. Right? Like, that's not cool. That's all under DMCA. But on the actual virtual tabletop, Roll20 doesn't know. Like, Roll20, you'd have to you're having to prove that you're arguing that Roll20 is a website and not a platform, and that its argument here is messy, and then I think that I honestly don't think this one works, right? Like, I mean, the easiest way for Roll20 to get around this is to say that they won't allow uploads of PDFs anymore, so that you can't share like that. But that doesn't matter because you can still go on to like a Google Drive and download your copy of a PDF to a Google Drive and share that drive folder with your players. So all of your players have access to the same book. Like you would share access to the same book with your players at a home table. So like I don't know that the VTT has the same obligations under the DMCA. I honestly don't. And I honestly don't think that's a question. But again, going back to it depends, I think it doesn't. But I think that's a question that would have to be litigated at this point. And I don't know how far it will go. You don't want to harm their development, but you do. You do want to harm their development because you want to protect your rights to your own development. Stop lying. It's okay. I like all of this makes sense. I understand a lot of these technical questions about like what is the line, you know, like is one multiverse more of an actual virtual tabletop or is it a video game? Personally, I think it's leaning a little bit more towards a video game. I could see it being required under law to have its own license, separate from the OGL. I think that makes sense. I don't know that this point about the owner or operator of the VTT being subject to the same obligations as anyone else under the DMCA. I don't know that that's true because it's like Roll20 and Fantasy Grounds already have their own licenses with D&D, right? Like they already have their own licenses. They sell PDFs in the marketplace. They allow you to recreate, you know, the spell compendium. You know, all of these things already exist. I don't know that it has the same issues. And if you're requiring them to have a license, you know, if they already have their own license, then they're not operating under the same thing because their license would cover anyone who's playing on the platform. Yeah, I think so Unstable Dios asks if Wizards of the Coast is conflating a VTT platform and a website which provides access to the VTT. Yes, so I would say that they are. I would also say that it is, again, this is all my opinion. And again, we are prefacing this by saying this is my opinion. I would say that it is definitely, conflating things. I think that they're trying to reach with this DMCA point because like if you get into Tabletop Simulator or Roll20 or Fantasy Grounds, they all have their own individual license with Wizards of the Coast for the content that they provide to players and GMs from Wizards of the Coast. But by the same token, you can play games. The platform is designed to play games as a meeting point that does not impede in any way, shape, or form the requirement to use Wizards of the Coast. It doesn't require you to use Wizards of the Coast content because the players can and GM can meet up and exchange information in a way that doesn't require that usage. So I honestly have problems with this general animated spell effect issue. Like in an individual game in Roll20, and you pull up an individual map in Roll20, and somebody casts Magic Missile, and they choose to, you know, like, pew pew. I don't... But on the other hand, you have one multiverse, which I do think is getting a lot closer to a video game in the best ways. And I think it's very interesting and I enjoy watching it. That's not the same thing as playing on Fantasy Grounds or Roll20 or even Tabletop Simulator, right? I don't know that this whole clause is complicated. So Jer says, I could see an argument for if the animation replicated the description of magic missile. Exactly. Like, if you, but even then, like, if I'm designing and creating the animation myself, or if the VTT created the animation itself and just had a general spell effect animation, then that's my creation, so you don't have any right to that. And if I'm using it tied to my player saying, well, I cast magic missile, okay, well, this is now the image of that, but that's not using Wizards of the Coast's image, or even, you know, I think that's where it gets fuzzy, because this document, the OGL, is specifically about published electronic static or PDF, you know, or EPUB formulas of written material for a game, right? Like, the OGL isn't designed to cover the VTT in the first place. That's why they have their own licenses. And it's why video games have their own licenses. It's why so I don't know that just seems to me like this clause I have concerns about. I would disagree with this statement. Now, they also have their, okay, why did you close? Okay, I want to look at the fan content policy, right? Okay. So, you can't require payments, surveys, downloads, subscriptions, or email registration to access your fan content. So if I create a spell effect, right? Yeah, it comes down to where does derivation end. Exactly. So, like, if I create a spell effect to apply when on a VTT, I don't know. It's not officially endorsed by Wizards of the Coast. It's not created by Wizards of the Coast. I'm not infringing on any Wizards of the Coast product there because I'm not creating a video game. I'm not infringing on any logos or trademarks or even their IP. See, this is where things get complicated. Don't use Wizards IP in other games. This includes your own or other people's games or game components, i.e. rules, books, tokens, figures, regardless of whether it is distributed for free. You can't use the video or fan music. Fine, we know that. Space censorship, fine. You can't, yeah, so your fan content, which is the videos, the fan art, the, you know, all of that, your cosplay, all of that would be covered under the fan content policy. I don't see how that would not be cover the general VTT. I cast magic missile and an animation goes off. Like, I could make it, or I think I could have a successful argument for that in court. But again, it depends, right? Like, all of this depends. I have some major concerns about this question about the DMCA. And I still believe that they can't enforce it the way they want. Because you can't... I could see the argument being made, like on Roll20, they can't just have... Roll20 can't just put the book up for free and have people take it. But the meeting point and platform and the sharing of content you're enforcing a standard on all of the individual games, which are all on Roll20, which no other game publisher has. And I don't, based on the fact that you already have individual licenses with them, I don't know that you can. Right? Like, there's a lot here that there are so many questions. This leads to more questions than answers. I honestly don't have enough of them. We would have to see and investigate and go from there. But at this point, think that's everything. I think that's everything. Overall, I would say that this new OGL is a lot better than the leaked document. It's a lot more similar to the original document. I still have a lot of questions, number one of which, it doesn't say royalty-free anywhere in that document. I have concerns about the lawsuit burden of proof shift. I have concerns about a bunch of things, but then again, any licensing agreement, particularly one that's like this, where it's open, and you aren't actually getting an opportunity to negotiate, although apparently now you can comment as a playtest, and that counts for negotiation purposes, probably. They'll probably treat it, like if anyone challenged this, they would probably treat it in court the same way challenge or commentary periods on federal regulations exist. By the way, if you didn't know, go on a bunch of, just Google search comment periods on federal regulations, and every federal agency has to publish any changes it wishes to make in their regulations, or new regulations they wish to adopt, and they are open for commentary from the public for a set period of time. If you want to engage with anything that any particular federal agency wishes to do, go look them up and see what they're doing, because that might be an important thing to do. Yeah, I still have some concerns, but overall, from an IP perspective, this document isn't horrible, and it's within the bounds of what they can do because it's their property. Like, I'm not defending them. I'm not white horsing for them, you know. White knighting, I should say. But at the end of the day, it's a lot more generous than, say, the DM's Guild. Just throwing that out there. But again, this has been just my opinion, and not legal advice, and in no way, shape, or form should be treated as such. Yeah, Hawkeye is better than before, but still has issues to deal with. This is true, but it is also marked clearly a draft, right? We know that this is particularly a draft. We know that there will be a number of revisions. I wouldn't get panicky or concerned until you see the final version. I would go ahead and comment on the D&D Beyond website. You can go ahead and comment on the whole thing. Go ahead on here, starting the OGL playtest, and there's, you know, provide your feedback in our survey, which will be live tomorrow. You know, they'll update it with the link. Once the survey goes live, you know, before February 3rd, it'll go live, and you know. Oh, it is live? Oh, there it is. Now, they have a survey. Survey says, answer the survey questions. And, you know, you can have take your time, go read through it, and see what they say, because I think that's going to count for basically the negotiation point of this license. That the court will treat that as a negotiation and commentary point. And give your feedback. And I'm not going to tell you what to say. I have points where I'm concerned, but again, you know, there are different people have different strokes, you know, different strokes for different folks. And according to Ice Bunny, yes, I am not giving you legal advice. Nothing I have said today is legal advice. I am required by law to say that. And it is true. This is not legal advice. Again, give them time, comment on it, and see where it happens, and go from there. But it is leaps and bounds above the previous draft. So, thanks for hanging out with me today. I really appreciate it. I have been... Would you look at the language of the forthcoming Open RPG creative license? For Unstable Dios, I will do a stream on them. I will do a stream on the orc. I haven't seen a draft of it yet. And I won't comment on the language until I see it in the language. But I haven't seen a draft of it yet. Now, if somebody has it, you know, I will take a look, but I haven't seen it, so that will be once it's available and I can see it. I'll do a video I'll do a stream on it. I'll answer questions. But thank you everybody for being here. Thank you for hanging out. I've been your friendly neighborhood Prax. Thank you for coming to the channel. Next up, we'll be back tomorrow with the season 2 premiere of A Song of Agapia's Fortune. Oddly, apropos of timing, that is our high-level D&D campaign. Lots of things happening. Lots of drama happened in season 1. If you want to catch up... Streambot. And there, why you know... Cloudbot, turn back on. There we go. You can check up all of the VODs over on YouTube. They're all very nicely, neatly organized. YouTube.com/@praxagorthesmiaphoria. You can also, if you like what I do here and you like hanging out with me today and what I said was helpful or beneficial in any way, I have a Ko-Fi. I use that to support the channel and support, Nojer, they started at level 14 and, I believe most of them are at level 16 right now. We're going to 20 though. But I also have a Ko-Fi. If you want to help us out, support that way, it is a great tool. It helps me support the channel and do fun things like this. I also, for those of you who don't know yet, have a merch store. There's a bunch of stuff in there, including the wonderful... I have to make this... Why the command not work? I don't know. You can get the Mechton, We Are Here to Make Interesting Choices hoodie, or long sleeves tee and short sleeve tee. We've got the When in Doubt Blame Iago hoodie, or and of course the which Yanto are you again? You can check those out. There will be a couple more going up in the next couple days. There are some mugs and bags, t-shirts. All of that supports me, and I tried to keep the prices down so that people could afford them, but they're pretty great. I think so. And other than that, this has been great. Thank you, everybody. Thank you for being here. I really appreciate it. We should go find someone to raid, send some love to, out into the universe, as they say. And, oh, we're gonna go raid Fawn, because Fawn is doing a charity stream for survivors, and they are currently playing Unpacking. Nice chill vibes, nice great people. Go love, send them some friends and happiness, and help them to raise some money for a good cause. But until next time, everybody, bye-bye.